because I know I've proved beyond reasonable doubt by taking polygraphs that I'm not a sex offender.
Okay, hold on.
Because I know I've proved beyond reasonable doubt.
The sex offender registration rules are by statute. And that means that somebody went to the legislature and got them to do some things and put some things in a list. And the governor signed it, and there you go. Okay.
I have notes from this is a case that Ms. Weiland has been appointed to. She would like to come back on this matter on the 4th day of June at 8:30 a.m. for a Rule 7. She will, Mr. Johnson will continue to waive preliminary hearing until that time. And I would like to note that we've received an offer, a plea offer from the district attorney's office, and we've received some discovery, including a probable cause statement, but we haven't yet received police reports in this matter, so she'll need to review.
Well, and the reason you haven't is because she didn't waive prelim last time. She set it for preliminary hearing, which was supposed to have occurred on the 27th, and we're supposed to be here today on arraignment. So what's the status of that?
Your Honor, we acknowledge receipt of the information in 14C 46286. Mr. Johnson indicates that he is correctly named. His date of birth is also correct. We'll waive any further reading or other advice of rights and seek Mr. Johnson's release.
All right, Ms. Wakeman.
Here we're asking the court to set $50,000 bail. Defendant, according to the reports, is a pimp for his wife. When caught in a hotel room, because his wife is getting hooked, defendant is there with $1,200 on him and oxycodone, 50 plus pills. He has texts that discuss selling drugs. He is a B on the grid with a prior robbery 2 where he went to prison for 70 months and a 2010 unlawful use of a weapon where he went to prison for 20. He was sentenced to 25 months. I'm wondering if he also has a parole hold.
Hold on. I'm trying to check. I don't show a parole hold, and did you show those charges when you looked them up? Can you give us the case number from the...
And it could be that his parole is done, but I don't think so. That's 09-06-32669. It's a Multnomah County case.
03069. All right.
Mr. Johnson indicates that he has completed his parole, his post-prison supervision.
Okay. Well, standard bail is $50,000. I'll set $50,000.
Your Honor, we asked for a preliminary hearing on May 27th with a return to court for arraignment and an indictment issue on May 29th.
Right. Preliminary hearing May 27th, May 29th, arraignment on indictment of limited issue, 8:30 in the morning.
I have notes from this is a case that Ms. Weiland has been appointed to. She would like to come back on this matter on the 4th day of June at 8:30 a.m. for a Rule 7. She will, Mr. Johnson will continue to waive preliminary hearing until that time. And I would like to note that we've received an offer, a plea offer from the district attorney's office, and we've received some discovery, including a probable cause statement, but we haven't yet received police reports in this matter, so she'll need to review.
Well, and the reason you haven't is because she didn't waive prelim last time. She set it for preliminary hearing, which was supposed to have occurred on the 27th, and we're supposed to be here today on arraignment. So what's the status of that?
It does look like there's emails in here saying that she was waiving prelim.
Okay.
So.
Yeah, I'm not trying to take a curveball. It's just we set preliminary hearing dates, and so I presume that was a day when she wasn't here when we made the assignment, and with the option that she could waive prelim once she had a chance to talk to the clients. And so she's prepared to do it. All right.
This is 14C 42686, State versus Matthew Johnson.
And this is on for Rule 7 today, Ms. Wyman.
That's correct, Your Honor. We'd like to set this over to June 10th. We've waived prelim and continue to waive prelim.
How are we doing on the 60 days, Mr. Hanson?
I think we'll be prepared to address that at our next court date.
First appearance was May 19th, I believe.
What was it, 19th?
May 19th was the first court appearance.
And 14C 42686. He is present out of custody, Your Honor. My client posted security and was released. At this time, I'd like to request that this case be sent over to July 30th at 1:30. I did send a request for seconds to great deal of discovery, electronic discovery. In this case, I believe a search warrant was written for some cell phones, laptop computers. I've asked Mr. Hanson to provide copies of all that, and hopefully you've got an email in your file, Gene, but I'm looking to get forensic copies of the hard drives and whatnot, so that's the reason I'm asking for a somewhat lengthier set over than normal.
July 30th.
Matthew Johnson, 14C 42686. I believe this is our second Rule 7, but I'm asking the court to set this over to August 27th. There's a significant amount of digital evidence in the case that we have to go through.
Okay. August 27th. And we're getting out there on this too. Started in May. And you think this?
We did not receive the digital discovery until less than 30 days ago.
Okay. August 27th at 1:30.
May I call Matthew Johnson?
Sure. Have a seat, Mr. Stutzman. Johnson?
Yes, Your Honor. One file, 14C 42686. Here at this time, we'd like to enter not guilty pleas. We have pulled Judge Tripp and are scheduled for a status conference on September 29th at 1:30.
And Mr. Johnson, I'm going to enter a not guilty plea on your behalf into the court record. It'll be assigned to Judge Susan Tripp, will be our trial judge. Have a status conference on September 29th at 1:30. We'll continue to waive preliminary hearing until the status conference date.
I don't know anything about your criminal history. Hold on. Right? I don't know basically anything about this case except that the charges are. Okay? I don't know anything about you. By my record, you've had a number of attorneys appointed by the court.
Yes.
Do you remember how many?
I have 4 of them and 2 substitutes.
Okay. You've had 4 attorneys and 2 substitutions by the court.
Yes, no.
What about the other 2? This case is going to go to trial. We all know that. This case is going to go to motions. We all know that. So let's all share information so that all that information gets on the record if that's appropriate. Okay? All right, this is the time set for an appearance on a criminal case. Would the state like to call the case name and number?
Thank you, Your Honor. This is State of Oregon versus Matthew Mayfield Johnson Jr. Marion County Circuit Court case number 14C 42686. The defendant's out of custody with his attorney, Ms. Ryder, and Nellie Wright for Mr. Hanson today. And we're ready to proceed, Your Honor. It's my understanding that we need to do an arraignment on the indictment. To address the motion to continue, and also, Your Honor, the state would like to put our amended offer on the record as well, Your Honor.
Okay, all right. It is signed as a true bill by the grand jury foreperson. The witnesses that appeared in person were R. Smith from SMP and E. Hernandez from SMP. Who's SMP? All right, Salem. Okay. And it was signed by Mr. Hanson for the district attorney's office on the 15th of October.
Witnesses that testified and I got a question about this Smith dude. What can you testify on about me when you never even talked to me? Oh, that he took $1,200 out of my pocket, but where did he find the $90 at?
attached document that's been filed with the court by the district attorney, issued by the grand jury. True bill means they found probable cause to investigate.
But
Right. It's time set for appearance. The state wishes to call the case.
Yes, Your Honor, we're here today for State versus Matthew Mayfield Johnson Jr., 14C 42686. Defendant is present out of custody with his attorney, Ms. Gail Ryder. I'm Tobias Tingley representing the state. We're here today for a motion to suppress due to some calendaring issues. It's sick attorney, so you're in day 3 of a trial, Your Honor. It sounds like unable to hear the full hearing today. We will be hearing from a defense witness, a doctor in the case, and then sending over the remainder of testimony for 6:30. That's June 30th at 2:30, or excuse me, 2 p.m. Your Honor.
All right, thank you. What's your full name? Spell your last name.
Andrew Ross Harbison, Harb as in boy, ISON.
Where are you employed?
I'm presently employed with the Rose City Urgent Care and Family Practice Clinics in Portland, Oregon, or the greater Portland area.
And are you familiar with the medical history of Matthew Mayfield Johnson Jr.?
Yes, I am familiar, as available on the records in that facility.
And did you have a chance to look at those records in the fall of last year regarding some diagnoses that were made?
Yes, I did.
And what did you see in those records?
What I saw in those records was that a diagnosis was made of diabetes mellitus type 2 sometime in the spring, particularly sometime in early May or late April of 2014.
And as a result of that diagnosis, was any particular course of treatment prescribed to Mr. Johnson?
Yes, a medication is prescribed, specifically a medication called metformin.
Man, I'm trying not to
Metformin, METFORMIN.
Thank you.
And during May of last year, was Mr. Johnson
That ain't no good
taking
news.
metformin?
My baby gonna be
Yes,
hurt,
to the
bro.
best of my knowledge, he was.
Just to clarify, were you the prescribing physician?
No, I was not. This was prior to my employment at the facility. His provider at that time, his primary provider at that time, had prescribed the medication.
Specifically on May 16th, 2014, was Mr. Johnson taking metformin? To the
Yes.
rest of he was under prescription.
By the review of the records, yes, he was.
It was under prescription, but you don't know specifically if he was taking it or not?
I can't say specifically that he was taking it, but he certainly was prescribed the medication, and I can confirm that the medication was obtained.
Okay, thank you.
Thank you. Are there, have you had a chance to review medical records from Salem Hospital regarding his treatment just after his arrest on May 16th, 2014?
Yes, I did.
And what were the symptoms that led him to be taken to Salem Hospital?
Nausea and vomiting.
Was the diagnosis of diabetes by another physician accurate?
At the time of his emergency department evaluation, the diabetes diagnosis stood. The reason for that is the emergency department's physician's ability to diagnose type 2 diabetes mellitus under the circumstances when he saw Mr. Johnson was not possible.
And I'm sorry, I want to make sure we understand your answer. Are you talking about the emergency room at Salem Hospital, or are you talking about the urgent care clinic in Portland?
So, as I understand the question, you want to know whether or not the emergency department physician at Salem Hospital was able to diagnose type 2 diabetes mellitus on May 16, 2014. Is that correct?
No, I'm sorry, and it's probably my inartful question. Is it your belief that the original diagnosis of diabetes and the decision to prescribe metformin was an accurate diagnosis?
No, I do not believe it was an accurate diagnosis nor an appropriate action.
And if one is prescribed metformin when one does not have diabetes, what is the body reaction?
So the body reaction to someone, whether they have diabetes or not, is not substantial. In other words, the effects of metformin on somebody who does not have diabetes is, for the most part, no different than somebody who has diabetes. However, the adverse effects that are related to metformin can be seen in both people who have diabetes or do not have diabetes if they're taking the medication. Does that answer your question?
And what would those adverse effects be?
At least a third of people who take metformin have gastrointestinal adverse effects. And of those, although there are percentages, nausea and vomiting can be substantial.
And that sort of nausea and vomiting might interfere with their ability to understand what's going on at any given moment.
I would say that to the extent that they're being ill, and the experience of being ill would potentially impair somebody's ability to act. Shall I say, clearly.
Right, thank you. Nothing further.
Mr.
Hey, we are. I'm about to go take sugar to the dispensary. Oh yeah, hold on, man. Hold on, don't say nothing real quick.
Thank you. Have you ever actually met with the defendant, Mr. Johnson?
In meeting in what type of circumstances?
In medical setting.
Yes, I've met with Mr. Johnson frequently since the summer of 2014.
And how did so since summer of 2014, that's when you realized it wasn't diabetes?
Yes, I took over Mr. Johnson's care in the summer of 2014 when I began working for the facility that I described earlier.
Okay, what's he prescribed now, and what is the diagnosis?
Yeah, there is no diagnosis now. In retrospect, I'll go into detail if necessary, but I believe that the diagnosis of type 2 diabetes mellitus was actually incorrect.
Did he have any health problem?
No, as far as type 2 diabetes mellitus, no, he does not have a health problem in that regard.
Yeah, you weren't at the hotel on May 16, 2014?
No, I was not.
All right, would this nausea cause people to engage in sexual behavior?
No, yeah, this is primarily an isolated impact on the body's perception of gastrointestinal distress.
What about to send text messages, that sort of thing?
I would say that actions can still, in other words, a person's ability to act are not necessarily impaired. But as I said earlier, whether those actions can be claimed to be of clear mental faculty, I would argue that's possible that they were not being done under clear mental faculty. As I said, based upon what I would consider a common sense experience of people, for most people who have experienced the nausea and vomiting, and what that sensation is like and how that might impact the ability to think clearly or act clearly.
All right, would marijuana benefit, or I guess help that nausea and vomiting condition?
Yeah, marijuana has been shown to actually improve nausea. It can improve nausea. The mechanisms by which are pointless to go into, but yes, it could.
And so, someone taking it wouldn't, because it's caused by the medicine, there wouldn't be an adverse effect with those two. I know
Would they
sometimes
interact?
medicine.
No, to the best of my knowledge, no, they wouldn't. Some of the evidence I've reviewed suggests actually that the use of marijuana for symptoms of metformin, nausea, and vomiting is not effective.
Is not effective?
Yes, but that's, of course, under clinical circumstances.
Okay. And have you had people in your office who are experiencing the nausea and vomiting?
I had people in the past, not present, but yes.
And were you able to have communications with them?
I was able to communicate with them. The circumstances under which I saw them, they may not have been acutely nauseating, any acute nausea or vomiting, but certainly they were able to speak with me. I've had people who have had nausea and vomiting, however, not necessarily related to metformin, who have had difficulty expressing their thoughts clearly, mainly because they felt ill. But with time, I would say that depending on the circumstances, I would say it would depend on whether somebody could speak with me clearly about a subject or not under the circumstances of those symptoms.
You weren't at Salem Hospital immediately after this.
No, I was not.
Right. You weren't there the day that the police interviewed the defendant.
No, I was not.
Right. So you don't know how he acted that day.
No, I do not know the specifics of how he acted. Yes.
Has anyone ever been untruthful with you in order to seek drugs?
I cannot verify that. I suspect it, but I cannot verify that.
I have nothing further.
Ms. Randall?
No,
All right, thank you, Doctor. I appreciate your coming. You're free to go.
Certainly.
Because that whole time, the first PO, he was. Hold on. Don't say nothing. I gotta click my next video.
As this court heard from Dr. Harbison, the metformin that Mr. Johnson was given did cause him nausea and perhaps some disorientation. Dr. Harbison testified that there were adverse effects to that prescription being given to Mr. Johnson when in fact he was not diabetic, and that prescription could interfere with his ability to cooperate and with his ability to make rational decisions. We would suggest to the court that his vomiting in mid-interview was indicia of exactly the kind of symptoms that Dr. Harbison is talking about, and we would ask the court to suppress both the statements that he made as not following.
And this is true. This is true.
And the search
So I can't give Gail Ryder the fact that she told the truth.
Yo, what? I seen it on, I seen Chris posted.
And that I did it.
About the doctor.
And that I did it.
About the doctor's testimony is.
How can he say anything about what my doctor said?
But he has no idea whether it had these effects on the defendant.
He don't either.
Heard that it had any effects on the defendant.
He don't either.
He doesn't, of course, have to testify, but there is no evidence before this court right now indicating that he was having trouble communicating because he was suffering from these effects.
Okay, there is evidence. It's my mental evaluation that Gail Ryder made me take. Why did she put motion to eliminate to get that eliminated? Because you didn't want me to show.
There we go. State versus call the case. Yes, thank you, Your Honor. This is State versus Matthew Mayfield Johnson Jr., 14C 42686. Defense counsel Gail Ryder is present with the defendant who is out of custody. Doug Hanson for the state. Your Honor, this is the time and date for a continuation of the motion to suppress that started last week on the 26th. It's my understanding that the defense had called a doctor to testify. That was just the brief testimony that was given at that time. There was cross-examination by the state. And then we are continuing the motion to suppress as well as deal with some other motions in regards to venue. The state is ready to proceed. We have two officers that are ready to testify. Ms. Ryder, anything further for the record before we begin?
Nothing for the record, Your Honor.
Get his hip back in place. Sure.
Under penalty of perjury, do you swear or affirm the information you're about to give in this courtroom call shall be the truth?
I do, Your Honor.
Have a seat.
Thank you.
Once you're seated, state your entire name, spelling your entire name out for the record.
Yes, ma'am. My name is Detective Rogers Smith. My first name is Rogers. Last name is Smith.
Counsel. Thank you, Your Honor.
Hold on. What you?
I'm trying to get my SSD now.
Mix into the hotel.
You might.
Most of the hotel have a very good relationship, and they will allow us to borrow room for a little bit so that we can kind of stage there. And then when we have the final location to go to, then we'll filter down and meet at that room.
You were not in uniform, I imagine?
No, sir, I wasn't.
Undercover?
Yes, sir.
How about the advance team? Are they in uniform or not?
Typically, they're not in uniform. However, they will take a backpack or some sort of bag that will conceal any of their duty gear or their body armor, things like that, so that they can try and look as normal as possible when they walk in.
So then tell us about how you, when you first physically met Miss Johnson in the hotel room.
Walked up to room 319 and knocked on the door. She answered the door and was wearing little to no clothing. She had a fishnet, I guess you would call it like a mini skirt or a dress, just a one-piece item, but it was very, very see-through. She had nothing on the top. Basically, her breasts were bare, other than the fishnet, and she was wearing a small pair of, I think, pink underwear.
Is this the same woman that you saw in the ads?
Yes, sir.
And then did you confirm with her that she was the person you were communicating with?
I did.
Tell us about your interaction then with Miss Johnson at that point.
I asked her if I could come in, and she stepped back and waved me into the room.
The second part will start in about an hour. Thank you guys for watching. Please like